The discussion today is about constitutionalism and transformative constitutionalism, two very important foundational concepts in constitutional law. Constitutions, you will recall from our earlier discussions, are documents that establish a state, that sets out the major branches of that state, defines their powers and functions, stipulates those, and works out the relationship between the branches of state and the individual. Now, in the wielding of governmental power, it has been human experience over many, many years that this power is susceptible to abuse. As long ago as 1887, Lord Acton, in a letter to the Bishop Mandell Crichton, wrote that power tends to corrupt, and absolute power corrupts absolutely. Great men, he said, are almost always bad men. Now, constitutional concepts, and the concepts that we are going to discuss from now on, are concepts that aim towards the limiting of governmental power in order to maximize the freedom of the individual. Constitutionalism, like many of the other concepts that we are going to discuss, has to do with the limitation or the confinement of governmental power. Now, the essence of the doctrine of constitutionalism is that the power of the state should be defined and limited to protect the interests of society. And this has to do, constitutionalism has to do with the exercise of governmental power in accordance with law, and in accordance, in the modern day, with a constitution. But this view of constitutionalism is not the only view of constitutionalism, that it has to do with limitation and confinement of governmental power. Dworkin, the influential jurisprudent legal philosopher, wrote the following: "By constitutionalism, I mean a system that establishes individual legal rights, that the dominant legislature does not have the power to override or compromise." So in other words, Dworkin sees a very particular link between constitutionalism and the protection of human rights. And if we unpack this doctrine a little bit further, we will see that this is really the essence of the doctrine, that the doctrine is about confinement, and that confinement has to be tailored towards the specific polity. Now, constitutionalism then requires that the competence and the procedures in accordance with which powers are exercised must be defined and restricted. Let's look at this again. It requires that the competence must be defined and restricted. So in other words, what may government do? What may the legislature do? What may the judiciary do? And what it may not do. So it circumscribes the competence, that which may be done by the different branches of state. And then it also circumscribes and prescribes the procedures in accordance with which powers must be exercised. So, for example, if the legislature is permitted to make legislation, that is a competence that is given to the legislature, then the procedure in accordance with which that legislation is to be made must also be stipulated to comply with the doctrine of constitutionalism. So constitutionalism is prescriptive, it is not descriptive. It prescribes set standards, but that prescription is also somewhat fuzzy, in that it also includes a commitment to the values of human worth and dignity. So constitutionalism is not merely follow the rule, follow the law, follow the rules. Constitutionalism is also about a commitment in terms and in relation to the exercise of power, to recognition and value being placed on the inherent dignity of every citizen, of every individual within the polity. So constitutionalism thus sets a standard for measurement and comparison. We can look at the competences, we can look at the procedures, and we can look at the commitment to the values of human dignity in a particular polity. Okay, Then, in the modern world where we live, we trust, there is a normative, and what is normative again? I'll remind you, normative is prescriptive. So in other words, this is if a state would like to claim that it subscribes to the doctrine of constitutionalism, it has to meet the following ideas, the following standards that involve or that is indicative of commitment to constitutionalism. In the first instance, a written constitution that prescribes the structures of government. And generally, this means, in the modern state, a subscription to the principle of trias politica. That is a division of governmental power into the legislature, the executive, and the judiciary. We'll talk about that in the next presentation. Sovereignty of the people. This means that authority to govern, authority to make laws, authority to execute laws and resolve disputes derives from the people. The people choose the government. They choose their representatives. Furthermore, also, judicial review is included in this basket of concepts that make up normative modern constitutionalism. And what is judicial review? Judicial review encompasses the authority, legitimate authority of the judiciary to review acts of parliament and acts of the executive for compliance with the Constitution. So it's an authority given to the judiciary to test the validity of the legislation passed and the acts undertaken by the executive for compliance with the Constitution. And then, as Dworkin indicated, it requires a commitment to human rights. And therefore, modern normative constitutionalism requires the inclusion of a Bill of Rights. Now, Louis Henkin, another influential jurist, added another set of ideas or elements that he required as essential for compliance with constitutionalism. Government according to the Constitution, separation of powers, sovereignty of the people, democratic government, constitutional review, independent judiciary, limitation of government subjected to a Bill of Rights, limitation of police powers, control of the military by the civilian authorities, and a restriction on the part of the government to suspend the Constitution. So what you can see is all of these ideas, Dworkin's ideas, Henkin's ideas, and our modern normative conceptualization points to the idea that the constitutionalism is about the limitation, the constraint of governmental power within certain confines of what is acceptable and what is not acceptable. What must be followed, procedures must be followed, who may perform what function, and in what way must a function be performed. Now, going back to the idea of written and unwritten constitutions, you will recall that we said in the United Kingdom there is no written constitution. So does that mean that the United Kingdom does not subscribe to the doctrine of constitutionalism? The United Kingdom knows constitutionalism because constitutionalism in essence has to do with a limitation of power in the interests of the citizenry. It has to do with delimitation of competences and prescription of procedures. And we cannot say that in the absence of a written constitution that there is no such commitment to human dignity, a commitment to definition of competences and procedures in the United Kingdom. It is easier, however, where there is a written constitution, to prove or to show or to measure that there is commitment to constitutionalism. As I've already indicated, it is not value neutral. Constitutionalism also requires a commitment to the values of freedom, dignity, and equality. Devenish says that constitutionalism requires a commitment to reason and deliberation and values such as equality, dignity, and freedom. Makwanyane, the very famous death penalty case, the court said that constitutionalism requires moving away from the arbitrary exercise of power to a culture of justification So in other words, if government performs an action, it must be able to justify that action. If the legislature passes legislation that encroaches upon a right, they have to justify that encroachment upon a right. And this idea of the Constitution as a bridge, or the Constitution as facilitating a break between the culture of authority with impunity under apartheid and the culture of justification under the new constitutional dispensation, was first publicized by Etienne Moreinik in an article that he published in the South African Human Rights Journal. And this commitment is to change, and that then brings me to the second topic that I want to discuss, and that is transformative constitutionalism. Now, in relation to transformative constitutionalism, I want you to pay attention, and I want you to read the article that I prescribed in this regard by Pieterse. What do we mean when we talk about transformative constitutionalism? The reference is in your course outline. Please ensure that you know what is meant by transformative constitutionalism. But before I go into what is set out on the slide, let me just quickly explain to you two different kinds of constitutions that we find. We find constitutions that are constitutive. So in other words, the Constitution establishes the state. And it says, this is the state. It has an executive, judiciary, legislature, and this is how they relate to one another, and this is how these structures relate to the individuals. That's constitutive. That's quite a static view of what a constitution is. And then you get a transformative constitution. And a transformative constitution is a constitution that not only establishes, yes, it establishes, but it also tries to show a way, lead the way to a different reality, to a more, in the South African context, egalitarian society. So there's a vision of what we are going to be when the constitutional promise is fulfilled. So transformative constitutionalism, then, in that way, where we have a transformative constitution, one that not only establishes but also aims to change, is a constitution, and transformative constitutionalism aims to dismantle the formal structures of apartheid. So in other words, it takes cognizance of the history of South Africa, but then it embraces this idea of the society, the egalitarian society, with substantive equality between people, not identical treatment of people, but substantive equality, taking our different contexts into consideration from that society that we are going to be once the constitutional promise is fulfilled. Now, it is very important to bear in mind that transformative constitutionalism is not limited to the public sphere. Our constitution is not one that only applies in the street and in the public park, and at the university, in the school, or the municipality, or the provincial legislature building. It applies everywhere, because our constitution recognizes that power imbalances exist everywhere in society, and that places an obstacle towards the creation of the egalitarian society that it aims to establish, where the inherent equal worth of each and every South African, irrespective of who they are, irrespective of any identity markers, where that is recognized and the person is able to fulfill his or her full potential. So what the Constitution thus envisions, and what transformative constitutionalism acknowledges as foundational to our constitutional project, is that this change that has to take place in our society must be rooted in law. This is not a change that can take place haphazardly. This is not a license to loot or invade or change this without any cause or without any direction that is being pursued. It is constitutionally mandated, and it is a commitment to societal justice based on equality. And the process of attaining that must be rooted in the Constitution, which commits itself to this better life for all. Now, in the lecture, we will discuss this further, and in the next presentation, we'll deal more pertinently with separation of powers, which provides more definite markers for you to hang on to in your conceptualization of this course. Thanks.